If you were recently arrested for domestic violence, there are 9 common mistakes that I have seen people make after getting arrested. So in this video, I'm going to be explaining to you what those mistakes are so that you can avoid them. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. But sometimes people make mistakes before they call me, or even sort of under the radar without telling me after they call me. And I want to share those. That's what I'll be doing today. 9 mistakes that people commonly make in these cases. The first mistake is thinking that because the victim does not want to press charges, you don't need to fight the case, you don't need to take it seriously, it can get dropped. This is a really common misconception. And, over the past 10 years that I've been doing this, I've actually seen that people are starting to realize this. That once the cops come out and they make an arrest, for the most part, it is going to be out of the victim's hands. And what the victim definitely can't do is decide that they're going to drop the case. It's not the victim's case, it's the government's case at that point. So just because the victim does not want to press charges does not mean that the case is going to be dropped. Number 2 is, let's say that you are still together with the victim. It's your husband, wife, whatever. And maybe you didn't actually commit any domestic violence, but there was obviously something that happened, right? There was at least a really bad fight. And then when you get arrested, it's pretty traumatic, especially if it never happened to you before. You're in the back of a police car, you're in a horrible jail that smells awful. Maybe it takes a while for you to actually get bonded out. You're really scared. You're in there with actual criminals, and it's a really bad time. And then you're like, oh my God, now I'm facing, felony or misdemeanor charges, whatever they are. Am I going to go to jail? Is my life going to be over? Of course, you, as the person who was arrested, are going to feel very concerned for yourself. But what I have seen over the course of my time doing this is that when you act toward your partner really self-interested, the focus of all of this is not like, I'm really sorry that we had that horrible fight, honey, and by the way, maybe I was wrong about whatever we were fighting about. Instead of including that, the arrested person will only focus on, oh my God, no, I'm facing these charges. This is really horrible. That is a recipe for disaster. And look, I am not a therapist. I'm not a relationship coach. I'm just a lawyer. But I have seen this happen again and again. And when I see men doing this sometimes. I'm sure that there are women too. I actually don't know if I've seen that necessarily, but I've seen men do this sometimes in front of me. And I will take them aside, my clients, and tell them, look, this is my advice. I mean, you can take or leave it. Of course, I'm a lawyer. I'm not your marriage counselor, but I don't think that that's going well. I'll see the look on their face, and when they switch it around, and act caring toward the person, you're missing work sometimes to be at court for this or to talk to me for this, but if they're there, so are they. Or thank you so much for coming, honey, and supporting me. All of that goes a long way. And when I see people doing the opposite, sometimes they also then end up making mistake number 3, which is, while the case is pending, get divorced or break up. That's a terrible idea. I've had cases where at the very beginning, the alleged victim is completely on my client's side. And maybe my client actually did nothing wrong. The cops come out, they arrest the man, and here we are. But through the course of the case, if they end up breaking up, if they're getting into fights, if they end up getting divorced, they're moving out, sometimes I'll see the victim come back and threaten them and say, I'm going to take you down for this. And especially if we have like a city attorney hearing coming up, where usually we get the charges dropped, that's really bad. So if at all possible, keep things calm. Definitely don't dump the alleged victim. Definitely don't get divorced. If they want to dump you, or if they want to divorce you, I would say it's on a case-by-case basis. Be cooperative. Don't refuse to move out or something. But I would just be conciliatory as much as you can. And if you can possibly avoid, if things are good at the beginning, keep them after the arrest. Keep them good. Just try to keep things right there until the case is over. It will definitely help you. Even though the case is not in the victim's hands, if we have the victim calling up the prosecutor saying, he's an abuser, this is horrible, I'm trying to get out, I want a 10-year protective order, that's not good for your case. Number 4 is, let's say that maybe you're not together anymore. Maybe this fight or whatever happened was actually you breaking up. So you're not together. Maybe you never lived together. Maybe you never really were together. Maybe this is more of a hookup kind of situation, whatever. Don't have any negative contact with that person. If there's not a restraining order in place and the two of you are texting, don't get into a fight. Don't call her, the B word. Don't do any of that. That's not going to be good for your case. And I know that this may sound very simple and very stupid, but the thing is that, maybe in your normal life without the case hanging over your head, you would have done these things. And people get emotional. People are afraid and more stressed out when these cases are hanging over their head. And it does happen. So just keep this in mind. If you find yourself in a situation where you are in an argument with the alleged victim, just walk away, stop texting, say, you know what, I'm going to call you back later, whatever it is, but don't have negative contact. That can be used against you. And if you're sending texts, calling her bad names or whatever, even if she's doing it to you too, and those make their way into the prosecutor's hands, the chances of charges being filed, more serious charges, a worse punishment, the case not getting dismissed when it might have otherwise, that increases greatly for you. Number 5 is somewhat the opposite of number 4 and number 3. Don't send any apology texts. Definitely not. An apology is an admission of guilt. I don't know if you've heard this advice before. I know I heard it when I was really young, which is if you get into a car accident with someone, never say, I'm sorry, right? And I'm not a civil attorney. I'm not a car accident attorney, but you don't want to say I'm sorry, even if you're sorry that the accident happened and you're not saying I'm sorry it was my fault, because it sounds like an admission of guilt. So do not do any of that. For the most part, if you're not in contact with the alleged victim after the arrest, like you bond out, someone else bonds you out, and you don't live with that person, I wouldn't contact them at all. If they want to come to you and contact you, that's okay. And if you are going to respond, ideally you have an attorney who can talk to you about what to say and what not to say. But I would not be contacting them. Number 6 is failing to submit a do not file packet. Okay, so I have a few videos about this because I think that it's so important. But basically, when you are arrested and you have a case, you have a court date maybe in like a month or 2, sometimes even 3 or 4 months from now, that means that the police have generated a police report and given it to the district attorney's office. District attorney has to look at the case and decide to file more serious charges, less serious, or go with what the police charged you with in the first place, or just dismiss the case and not file anything at all. Now, obviously, dismissing the case is your goal, but if you do nothing, it is possible that on their own, without any kind of intervention from you, without hearing your side of the story, good things about you, any of that, it's possible that they will decide not to file or make it less serious. But don't you want to maximize your chances that they will dismiss the case so you can be done with the whole thing, possibly never even have to go to court? The way to do that is to have an attorney, and this is not a DIY project. Do not send your own statements to the district attorney. Absolutely not. But hire an attorney to file a do not file packet, talk to the DA, and in that include your side of the story in some cases, depending on what that is, a statement from the victim if they're on your side, letters of recommendation, good things about you if you are working, going to school, have a family, basically are a good, productive member of society. The DA will not know that when they're making this decision unless you put that information in front of them. So when somebody books a consultation with me, one of the first things that they have to tell us is, have you already had court? And many times they have already had court. And it's a case that I think, hey, I probably could have gotten this dropped before, but now you already had court, which means that the case was already filed. And it's too late. We can't go back. We can try to get it dismissed now, but it is much harder to get a case dismissed once it's already been filed than to get them to drop it before and never even start the case to begin with. Number 7 is failing to go to either domestic violence classes, therapy, if there was like a lot of drinking involved, and that's probably in the police report, AA, whatever, you should be taking some kind of class or doing something between the time that you were arrested and your first court date. If you've already had court, you should probably start going now. So domestic violence classes, those can be a little bit hard if you don't have an attorney to get into, which sounds weird, but for the court-approved ones, sometimes they want like a letter stating why you're going. And basically you have to explain to them, hey, I'm going preemptively. I'm going before court because I want to make sure that I have some of these classes done. Sometimes they get confused. So if you have an attorney, they just send them a letter and it becomes very clear why you're doing this, and we make sure that you get credit for it. But the other option is even go to therapy. If you're still together, go to marriage counseling, or if you're not married, couples therapy. Do something so that your lawyer, if it's a public defender, if it's a private attorney, can use that to show, hey, this person sees that there's a problem. Not that you necessarily did anything wrong, but obviously something bad happened that you got arrested, even if it was just a loud argument. And this arrest scared the crap out of my client. And so he's taking all of this action to make sure that he never ends up in the same place again. That goes a really long way. And if you wait for your court date to do that, maybe you're thinking, well, she said, my case might not be filed. Why should I have to go to 4 months of therapy or domestic violence classes? I'm really busy. Okay, it's absolutely, first of all, that can be submitted with a do not file packet. Second, it's absolutely worth it if you can potentially get the case dismissed or not end up with, a felony record, potential prison time, or even a misdemeanor record and potential jail time to go to these classes. It's absolutely worth it. And third is if you wait for court, the case is filed, and you start going then, the judge is going to want to move the case along once the case gets filed. So you may not have that much time before the judge says, all right, take your offer, whatever that may be, or I'm going to set the case for trial or preliminary hearing in a felony case. You may not have that much time to get that many under your belt. And the more that you have, the better it looks for you in terms of trying to get the case reduced, trying to get classes in exchange for a dismissal, something like that. So you want to start as soon as you can. Number 8 is putting your life on hold. Now, these things can obviously take quite some time to wrap up. First of all, if your court date isn't for a few months, well, it's probably not going to get resolved until at least close to your court date if you submitted a do not file packet and have an attorney. But if the case is actually filed, now you're looking at, depending on the case, maybe 6 months, maybe a year that this case is hanging over your head. So I've had people tell me, well, I'm waiting to apply for a job until my case is resolved, or I'm waiting on whatever. Don't do any of that. Just move your life along, proceed as normal. Don't let this case just completely take over your life. And number 9 is my personal pet peeve, especially when it comes to TikTok. Do not post about it on social media. Again, this is one that sounds really silly, but people do this all the time, especially in restraining order cases. My client will be like, oh, and let me show you all the TikToks that I made on this and all the TikToks that she made. I'm like, what do you mean? Why would you be posting TikToks about a case? And then I'm looking through the other parties, seeing what can I use against this person. Don't put things out there for your opponent to potentially use against you. No matter how funny it is, no matter how nice it is to vent or have people like it or whatever, it is not in your interest to do so. Even if you're saying I'm absolutely innocent, this is bullshit, don't think like there's some sort of loophole and way around this where it's advisable to post on social media about your case. It is not. I hope that you found this video helpful. If you do have a domestic violence case or another criminal matter in California, feel free to book a consultation with me down below. You can also give me a call. You can find my number there.